Welcome to Hankey Marks Crider. Thank you for choosing us to represent you. We understand that picking an attorney is a really big decision, and we truly appreciate the trust you've placed in our team. We are committed to guiding you through every step of the process with dedication and care.
The intent of this video is not only to welcome you to our office, but to also give you a high-level overview of what working with our office looks like, as well as an overview of the disability process as a whole.
If you ever have any questions or concerns, we're always here to help. You're now part of our community, and we're honored to stand by your side.
We look forward to working with you and fighting for the best possible outcome. Welcome aboard to Team Hankey Marks Crider. In this segment, I'm going to cover a broad overview of what it will look like for you to work with our firm. First, it's important to know that all of our attorneys work together as a team. For most cases, claims are denied at both the initial and reconsideration levels, and a hearing in front of an administrative law judge will be required. While we wait for your hearing and your case moves along, you will have an assigned case manager here in our office. Think of your case manager like you would your nurse to your doctor. They are working closely with your attorneys, keeping your file up to date and answering all your questions. We often get asked when should a client reach out to their case manager, so I wanted to highlight a few of those important times. If you change your address or phone number, let your case manager know right away. It's very important that we be able to reach you. If you obtain a new diagnosis, you're referred to a new doctor, or visit a new medical facility that you have never told us about before, please let your case manager know. If you receive a correspondence from Social Security that you're unsure of, give your case manager a call. Everything that Social Security sends to you, we should be copied on and can help you work through what, if anything, you need to do with that correspondence. Let your case manager know if you start working, even part-time. Social Security has limits on what you can earn while filing for disability benefits, so we can monitor any work activity to determine how it may impact the viability of your claim. Let your case manager know if your marital status changes. For SSI claims, a spouse's income is counted as part of your household income. If you have any other questions that are not encompassed in this video or questions that come up as you go through this process, please feel free to reach out to your case manager. If your question is ever something that your case manager is unable to answer, they will discuss the matter with your attorneys and set up a call if necessary. Remember, we are all working as a team on your behalf. As your case moves along, there may be other individuals in my office who need to speak with you. For example, if your claim was denied and needs to be appealed, my appeals specialist would be contacting you. Good news though, if you ever need something in our office and are unsure of who to call, all you have to do is call our main line. Every team member that touches your case makes notes in your file, so everyone else can see all the activity. Our receptionist can very easily look you up and make sure that you're transferred to the appropriate team member to assist you.
There are two main types of disability: Social Security disability insurance, commonly referred to as SSD, and supplemental security income, commonly known as SSI. Both are forms of disability, and one must prove the same level of disability in order to be granted these benefits. However, there are differences between these two programs. SSD is a type of disability one pays into through their taxes from working. When you pay in your Social Security taxes, you're not only paying into retirement, but you're also paying into the disability program. To put this in simple terms, this money from your taxes buys you coverage for disability through the federal government in the form of SSD. You build up work credits that transform into coverage through this program. Once you stop working at a level where you're building up work credits, those credits do begin to dwindle and they will eventually expire. So you only have a limited amount of coverage once you cease working. This is why it is so important to apply as soon as possible once you stop working due to your disabilities. SSI is a form of disability for children or for those who have not built enough work credits to be covered for SSD. However, there are additional hurdles for eligibility with this benefit. To be eligible for SSI, one's household income must be under a certain amount. If you have a household income above this threshold or are receiving assistance through other individuals or programs, then Social Security could find that you are not entitled to the SSI benefit. During your initial consultation, our team will determine whether SSI would be an appropriate benefit for you to apply for based on your particular situation. Often, we will have clients apply for both benefit types. This covers these bases and protects the client in the case of an issue with their insured status with SSD or lack of full eligibility with SSI.
We often assist new clients who have not yet started a disability claim. There are several different ways that you can file for disability benefits depending on the type of claim you're pursuing. During your initial consultation, we will have identified what we believe to be the best way to get your application started. For most of our clients, we prefer to set up a phone consultation appointment. We set up a dedicated day and time for you to speak to Social Security to make sure our clients are speaking to the correct person and being signed up for the appropriate programs. During this phone application appointment, there are a few things that can make your appointment run more smoothly for you. First, have a list of your diagnoses. Please note that you do not have to have your actual medical records. Social Security is going to order those initially to make sure everything is being submitted, and from there, we'll take over ordering your records. I would also have a list of your recent medical providers with their contact information and a list of your current medications. In addition to these items about your medical conditions, Social Security will need information about your past work history, but only for the last 5 years. They will need to know a brief description of what type of work you were doing, clarification on whether the job was performed seated or standing, and an estimate of the highest amount of weight that you would need to lift.
Getting the initial denial from Social Security can be quite disheartening. Many people stop there and feel if they've been denied by Social Security once, what's the use in moving forward? I can tell you, the vast majority of those that apply do in fact get denied at this first application. Try not to get discouraged. This initial denial is not a reflection of the strength of your claim. The first step is unfortunately taking longer and longer, and we are seeing this step averaging several months. However, once you receive the denial, we only have 60 days to file the reconsideration appeal. Our appeals specialists will be reaching out to you to gather the necessary information to file this reconsideration appeal on your behalf. During these lower level parts of the process, we are in a hurry up and wait situation. We have constraints of time and deadlines, but Social Security does not. Unfortunately, we have very little control over how long it takes them to process their side of things. This wait can become incredibly frustrating and financially hard. We realize this and we want to help in every way that we can, but please understand, we can't make a government agency move any quicker. Some of the procedures and timelines are just out of our control. Please note that we will do everything we can on our side of things to move your case along timely and efficiently.
Unfortunately, it's very normal for your reconsideration appeal to be denied. Please don't feel like this is a bad sign. We would not take your case if we did not believe in the merits of your claim. If you receive a reconsideration denial, we can appeal this for you. To complete this appeal, our appeal specialist will be contacting you. If you would happen to miss this call, please make sure that you call them back as they will have some important questions to go over with you to complete this appeal. During this stage of the process, we often find ourselves in Social Security's waiting game. While we must adhere to strict deadlines and time constraints, Social Security does not operate under the same urgency. Unfortunately, as attorneys, we have little control over how long it takes for them to process their side of things. We understand that this can be incredibly frustrating and financially challenging, and we want to support you in every way we can. However, please know that we cannot expedite government agency timelines as some procedures and delays are beyond our control. Rest assured, though, we are committed to doing everything possible on our end to move your case forward as efficiently as possible. By submitting this appeal, we are now requesting your hearing in front of an administrative law judge. And good news, while not guaranteed, it is at the hearing level that claimants have the best chances of approval.
The hearing level is the big step we have all been working hard to get you to. This is a step where all the pieces of the puzzle finally come together in front of an administrative law judge who will be deciding your claim. Prior to the hearing, you will have a meeting with your attorney to go over what you can expect at that hearing. At that time, the attorney will prepare you for the hearing and make sure we have all the evidence we need for the hearing. If you have any questions regarding the hearing, that's the time to ask them. The attorney will also know the judge that you'll be in front of and can give you guidance on how that particular judge runs their hearings. There are currently several hearing formats being used by Social Security: phone hearings, video hearings, or in-person hearings. Most hearings occur via the phone, and that is a type of hearing that usually gets scheduled the quickest. If you would like a video hearing, you must have access to the technology to do this hearing via Microsoft Teams. If you prefer an in-person hearing, you must be able to get transportation to the hearings office. Requesting an in-person hearing may delay scheduling your hearing due to the judge's limited in-person availability. Whatever type of hearing you choose, they will mostly operate the same way. Only you are allowed to be present, along with your attorney. In the hearing, there will also be the judge, a court reporter, and a vocational expert that is there to speak about jobs. Your testimony is the main purpose of this hearing. The judge has the medical evidence in your claim, but wants to hear from you about how your disabilities limit or impact functioning in just day-to-day life. The hearing will last about an hour, and we will likely not get a decision that day. The judge will go back and study your medical records more after getting to hear from you, and then they will issue their decision in a formal written legal opinion. This opinion will get mailed to you and your attorney several months after your hearing date. Once your benefits have been approved, you now move to a different office within Social Security, the Payment Center. Once the Payment Center is notified that you've been awarded, they will assign you a caseworker that will contact you to go over basic information and establish what your monthly disability amount will be, as well as what your back pay is and how it will be paid to you. They will need bank account information and payee information if a payee was ordered. This step of the process really depends on how backed up the Payment Center is. Please understand it may be another few months before you receive any money from your favorable claim. Since Social Security mandates attorney's fees in this practice area, Social Security will pay our attorney fee directly to our office out of your back pay. The only bill you would receive from our office after a favorable decision is for the costs of your medical records. However, if you ever receive a bill from our office before you have received your back pay, please call our office and let us know.
While the hearing in front of the administrative law judge is a great opportunity for benefits to be approved, sometimes the judge makes the wrong decision in our opinion and denies the claim. If this happens, we will review the decision to determine what is the best course of action for you. If you're denied at the hearing level, you have to decide whether to appeal the decision to the Appeals Council or start a new claim. Your attorney would carefully review the decision to determine if there was significant legal error. If there was, the claim would be appealed to the Appeals Council. If appealed to the Appeals Council, you would not have to attend another hearing there. If the Appeals Council agrees with us that there was significant error made, it would be remanded, meaning sent back to the hearing level for a new hearing. It is extremely rare for the Appeals Council to approve benefits on their own accord. If the appeal is denied by the Appeals Council, we also file claims in federal district court. Just so you understand where this is, such an appeal would be 2 levels below the Supreme Court, so it's very high up there. We have an attorney who focuses solely on this federal district court work. They will review the decision and determine if the case is one that is appropriate to file in federal court. And just like at the Appeals Council level, at the federal appeal level, you will not have to attend another hearing. The attorney will write a brief, and if the federal court agrees there was significant error made, the case would be remanded or sent back to the hearing level for a new hearing. It is important to us that we make sure our clients are aware of all the practice areas that we handle. For injury cases, we handle personal injury, wrongful death, and products liability. We have experienced litigators that have handled everything from vehicle accidents, slip and falls, dog bites, pedestrian accidents, drownings, and everything in between. On the disability side, we handle short and long-term disability claims. These are insurance policies that were either privately purchased or provided by an employer, and when you go to use them, the benefits are denied. We also handle veterans' disability benefits. Please note that in all our other practice areas, we offer free consultations and work on a contingency basis, meaning we only get paid if we get a recovery for you. No matter what legal matters you may face in the future, we hope to be your first call. Even if the matter does not involve one of our main practice areas, we take great pride in making sure our clients get pointed in the right direction. At Hankey Marks Crider, we know that choosing an attorney is a big decision, and we don't take your trust in us lightly. We're honored to be in your corner, and please know that we are committed to fighting for you every step of the way.
If you ever have any questions or need anything, don't hesitate to reach out. Thank you for allowing us to be part of your journey. We look forward to achieving the best possible outcome together.